Will pretrial motions be filed in my case? Pretrial motions are written requests that either the state or the defendant makes to the court. The side filing the pretrial motion is asking the court to make a ruling one way or the other that it hopes will benefit it in the case. Different motions have different purposes. One of the most common motions that a defendant will make is called a motion to suppress evidence. In such a motion, the defendant is asking the court to exclude certain evidence because it was unlawfully obtained by the police. For example, if evidence was illegally found or obtained in violation of the Fourth Amendment, it should be ruled as inadmissible. The lawyerly sounding term for this is that the evidence should be suppressed. And all that means is that the defendant and his or her lawyer are asking the trial court to not allow the evidence to be used against him or her in the trial because it was not properly or lawfully obtained by the state. Occasionally, in a pretrial motion called a motion in limine, a party, either the state or the defendant, is asking the court to rule that evidence is admissible in the trial of the case. These motions are sometimes filed when the lawyer anticipates that the other side will try to prevent or object to the evidence being used by the defendant at trial. Based on the specifics of a particular case, it is sometimes better to go ahead and get a pretrial ruling by the court so that you will know ahead of time whether you can use a particular piece of evidence at trial.